They'll offer you, okay, your vehicle is out of service for 30 days. We'll give you that 1 month payment back. Or we'll give you some free oil changes, when really under the law, they owe you a bit more than that for the issues, even if they are minor. You're owed a percentage of your purchase price back. I'm Emma.
And I'm Courtney.
And this is Lemon Law Unpeeled, the Lemon Law Podcast. Today, we're going to be talking about different defects that you can have in your vehicle, what defects rise to the level of lemon law, and what defects fall under breach of warranty, or on the flip side, when you might have a minor defect that initially starts off that way, but then rises to the level of lemon law. How do you know when you're there? How do you know what to look for? And all those sorts of things. So I guess first we'll kick it off just talking about common issues that we see in vehicles that minor is probably not. I don't mean to diminish it by calling it minor, right? I mean, any defect in a car is definitely a problem. But I guess those that are in your face lemon law safety issues, what are some common issues that you see, Courtney, that don't quite rise to that level, but fall, usually within breach of warranty?
I think, Emma, the most common thing that we're seeing is the infotainment system issues, right? I mean, that's the main control hub of the car that people are so reliant upon in the last few years, with navigation, with phone, with Bluetooth, all of that. I mean, just 10 years ago, maybe everybody had the Garmin and the TomTom externally plugged in, and now it's always part of the vehicle. You plug your phone in and you're expecting it to go through the car's Bluetooth. And that stuff constantly isn't working across the board with all manufacturers. Everybody has an issue with that. And that's one of those things that we just don't see a buyback for, because the car is still accelerating, braking, steering. The car is still working for what the car is supposed to do. It's really an accessory. But it's so incredibly frustrating because it's, as you and I both know, and I think anybody can understand, if your phone, your navigation, your radio isn't working, it's really disruptive to what you're doing. A lot of times clients will say, well, it is a safety defect because I have to keep looking down at my phone, or I have to do this or that. Unfortunately, the courts are not viewing it as a safety defect because you don't need it to drive, but it's something we can absolutely recover money for breach of warranty.
Yeah, these infotainment systems have become a new recurring issue as of late, right? Because cars didn't really have all these computers and fancy systems in them before. And when we say infotainment system, we mean the screen that you have that's generally in the middle of your front dash, that has your radio, your Bluetooth. Some cars now, it even controls the HVAC system and things of that nature that are all within that unit and controlled by that unit. And Courtney is right in that, generally speaking, the courts don't really see that as a safety issue. That's not to say that there have been some cases in which vehicles have been repurchased for Bluetooth issues. But for example, I had a case where a vehicle was repurchased, but it had been sitting at the dealer for 4 months out of service because it needed some sort of new backup camera that they didn't have in stock and they'd been waiting for. So the car was just sitting and sitting and sitting with no repair date in sight. And even then, when I was talking to my client, I was saying, we have to hedge our bets. We may not be able to get the buyback here. And the manufacturer did ultimately buy it back. But that was one of those more extreme situations where that sort of thing happens, because it can be tough to relay to a judge or jury that the failure of your Bluetooth or navigation system are a safety issue in terms of the drivability of the car. Because I have a lot of clients that say, well, it took me to a bad neighborhood and I was stuck in my car and I didn't know where to go and I didn't know what to do, and anything could have happened. And that's absolutely true. And that is a frightening situation to be in. I have parents calling about their daughter's car, right? She's out driving and her phone isn't connecting. Her navigation's not working. She's lost. And it's a very scary situation. But as Courtney aptly pointed out, these issues are routinely sort of seen as accessories to a vehicle, not a requirement for a vehicle to be safe. Because as I described to a lot of clients, we didn't always have backup cameras. We didn't always have navigation in cars, and they still were considered safe. So you kind of have to look at it through the lens of, is this required for the vehicle itself to keep me safe, or is it just a nice accessory to have? That seems to kind of be the dividing line which comes up really crucially, and these new systems that they have for like the collision control and the safety assist. Courtney, what's your experience with these new features that we have, these safety features for lane departure, automatic braking, things of that nature that cars are starting to have now?
Yeah, and you touched on a good one with the backup camera too. I think the backup camera kind of goes hand in hand with this collision mitigation, lane departure warnings, all of that. Are they there for safety reasons? Yes. And our clients always, rightfully so, point that out to me. Hey, I wouldn't have been able to see this child by just turning my head and looking behind me. I needed that backup camera. Same with the collision mitigation. I wouldn't have known that this small animal was in the road and I was going to hit it if not for that. So are they technically there for safety reasons? Yes. But as I actually had a judge say to me once, I drove my vehicle 20 years ago without this system. And if we were able to drive vehicles as what we viewed as safely 20, 30 years ago without these systems, they're generally not falling under safety issues that are egregious enough to warrant the buyback under the Lemon Law. Now, will a manufacturer sometimes voluntarily buy it back for those reasons? Sure, and sometimes they will. But if push comes to shove and we end up fully litigating and we end up on trial in a courtroom, are those systems going to get us the buyback? Usually not. And I totally understand where our clients are coming from because, yeah, it is a safety. Those are safety features. But again, like that judge said to me, if the vehicle was able to be driven without it, it's generally not going to rise to that level. Now, should you shy away from bringing a claim because of that? Absolutely not, because we're very easily able to get money for these issues, but it's generally not going to be a buyback.
Yeah. And it's getting harder and harder sort of to find this line between minor and major issues as Bluetooth is standard, navigation is standard now. Those used to be upgrades that you paid for. But now that they're standard in all of these vehicles from a Kia to a Mercedes-Benz, the lines are being blurred now as these systems control more of the car. So the biggest example is the HVAC, right? If your air conditioning and your heat are controlled through the infotainment system, which I believe they are in a lot of like Jeep vehicles, at what point does the failure of that system when you're in, 90-degree heat and can't turn your air conditioning on in your car, or vice versa, it's 9 degrees out and you don't have any heat. At what point does that start to bring the level up when the HVAC cannot be controlled by the system? And correct me if I'm wrong, Courtney, but I kind of see it as, well, is the HVAC system still on and functioning, or is it not turning on at all and you're left without it? But that, again, it's a gray area. It's a tough one.
Yeah, I think that really is tough. And like you said, is it just that the AC isn't getting as cold as it should, but you do still have it? And then another thing that goes hand in hand with that is your defrosters. I've had people say my front windshield isn't defrosting because that's all part of the HVAC system. And that absolutely can be a safety issue. And like you said, it really is a gray area. And I think it not only depends on the manufacturer, the actual rep that's assigned to your case from the manufacturer. And if you're talking about sitting in a courtroom, what arbitrators do you have on your arbitration panel? What judge do you have? Because it really is a gray area. And those are those things that can go either way. But I think you're absolutely right where you said, I think the trend is changing now that these things are becoming standard. I don't think it's really fair to think about, well, we didn't have these things 20 years ago, so they're never, ever, ever going to qualify as safety defects under the Lemon Law. It's really not a fair way to look at it. So I'm hoping, and I do believe that it is, that trend is changing and we're starting to change our view of what we think is safe versus what we think is just an accessory.
Yeah. And a lot of it too, as we always circle back to, depends on, is the dealership duplicating this problem? So if you're bringing it in and you're saying that my climate control, I can't control it, it's gone away, can they duplicate it? Do they acknowledge that it's not working? Do they acknowledge that, hey, because a lot of times what they do, if you say, I can't control it, but air is still coming out, they put a thermometer on the vents and they see what the actual temperature is that's coming out of the vehicle. They'll test the defrosters. They'll see how long it takes for your front windshield to defrost when it's at their service department. And what's tough is you can't control the weather. So you could be bringing in for the defrosters not working, but we just happen to have, a 60-day day outside in the middle of winter, which does happen, and nothing can be duplicated. So it can be frustrating, but like you said, it shouldn't stop you from bringing the case. take pictures, videos, do everything you can possibly do to try to document it yourself, and don't give up on the dealer. Maybe try to look at a 10-day weather forecast. Okay, what's coming up? And work with the dealer ahead of time to say, listen, is there a way that we can make this work? Because I need this temperature. I need it to be like this for you to see these problems. I mean, you do the best you can, but it can be really tricky.
Yeah, absolutely. I think so much of it comes down to what's verified and what's duplicated. And I always tell people those videos and those pictures, they're helpful to us when we're trying to get money out of a manufacturer, when we're in a courtroom, but they're also really helpful to the dealership. So I always say, show them to the techs, because sometimes, yeah, it's true. Maybe the tech, maybe the dealership isn't quite going to believe you. But if you're able to show them that video, a lot of times they'll take you more seriously and realize, oh, there really is a problem here, and work harder to try to find it. Because as unfair as it may be with some of these dealerships, sometimes it does come down to how much are they really trying to find your issue. Do they believe you? And sometimes it really comes down to your relationship with them too. And this isn't something that we see all the time, but sometimes people can be very angry and very frustrated. And I think it tends to rub the dealership the wrong way a little bit. I always say you get more with honey than with vinegar, right? And it's hard not to be angry when you're at the dealership and you're having this super inconvenient, frustrating issue when you're taking time out of your day. But if you can be kind and be respectful to the guys there and the gals there, a lot of times they will just strive that much harder to help you. And when they're able to verify or duplicate that issue, it makes a world of difference to these cases.
Yeah, but it's not a perfect world. Some dealerships could care less when you walk in with a video or not. But like you said, it still helps the case. So if you bring the case and we can go into court or show it to a rep or something, it helps show that the problem is there. It's so much stronger than you just testifying to it. And there have been cases that I've seen of late where some of these issues can eventually escalate into lemon law issues. For example, there were some trucks that I was seeing that were having radio problems initially to start, right? Just a problem with the radio, no big deal. But eventually from that malfunction in the radio, it was causing the vehicle to no longer start. And a no start condition, I would say, is definitely the most common buyback lemon law problem that I see, hands down. The vehicle not starting, it's hard to argue with that that's not a safety problem. There are exceptions to that, right? If you're not driving your vehicle enough, that can be an issue, especially with all the computer systems that we have in vehicles now. You do have to drive it. You have to keep it charged. You have to get that vehicle moving. You can't just let it sit in your driveway for 2 weeks and expect it to start up on you. But an actual true, I'm driving it every day, it's my daily driver, I go out there and it doesn't start, those are issues that definitely escalate to the level of lemon law that I see most commonly. Courtney, what are some issues that you've seen that you find to be most common for actual lemon law safety defects?
Anything that's going to cause the vehicle to stall or to stop driving while you're driving down a major highway, a turnpike, for instance, is certainly going to get the vehicle brought back. The things that are more like hesitations, a shudder, things like that are really tough. It's mainly, like you said, the no starts, the stalling, that I think are probably the most common. I would make the caveat with the no start. It actually has to be when you've physically gone out to your vehicle and tried to start it, not with a remote start. Because a lot of times I have people say, I have a remote start installed and it's not working. Or sometimes they'll just tell me the car's not starting. And then upon digging a little deeper, I find out, well, it's actually only when you're using the app on your phone. Generally, anything that involves the word app is not going to rise to the level of the lemon law, unfortunately. Emma, I don't know. Can you think of anything else other than the no starts and the stalling that really generally oftentimes get you the buyback?
A failure. So if you're pressing on the gas and the vehicle doesn't go, we saw that a lot with the Ford and Fiestas back in the day where you'd press on the gas and the car just does not move. Braking concerns, right? The vehicle actually failing to brake when it should. I've had clients with what you would call like a spongy pedal where they're pushing it and it basically has to go all the way down to the floor for them to be able to stop. Things of that nature are usually what rise to that level of needing a buyback. Or most recently, you and I had a buyback where we had to have our expert take a look at it because there were so many different electrical problems happening. So there's this new system now in some of these trucks where the cruise control monitors your eyes. So it makes sure that you're still there and you're still alert, while the vehicle is in cruise by monitoring your eye movements, which is nuts. But that was one of the systems that was going haywire, along with other major computers and modules that had to be replaced for other electrical concerns that were cropping up too, with the cruise control not working and things of that nature. And that actually rose to the level of a buyback. But again, it's because actual modules or computers in the vehicle were malfunctioning. So it was more than just, oh, I have a glitchy system sometimes. Sometimes the Bluetooth works, sometimes it doesn't. These were the actual computer systems that controlled the Super Cruise and other electrical systems in the car that were failing. So to me, that was another vehicle with all these new systems that's sort of, like you said, paving the way to rise to that level of Lemon Law. But you're right in that most of them are like actual failures of the steering. Remember, we've had the death wobble before where the steering wheel is shaking so violently you can barely hang on. We've seen issues like that rise to the level of Lemon Law. But again, the common theme in them is that the vehicle itself is basically breaking down. Like it's just not functioning.
Yeah, absolutely. And one other while you were talking that I realized I do often see is water leaks when it's so bad that the water is actually pouring into the vehicle. I actually just had one just last week. It wasn't a little trickle, and sometimes I feel like the vehicle's damp. It was a water leak that they had tried to fix multiple times and just couldn't seem to get a hold of. If it's a leak that they've been able to fix, short of there being mold or mildew or something in the vehicle, generally that's not going to rise to the level. But a really strong water leak that they're not able to fix, that will generally also warrant the buyback.
Yeah, water leaks are another gray area. You're right. It's tough. I mean, I've had clients where they send a video where you can hear it sloshing in their door, that's how much water there is, but there's actually a hole underneath your door that when you open it, all the water comes out. And that is actually how it's supposed to function. It is supposed to drain out like that, but it was like a waterfall. But again, the manufacturer is saying that's normal. That's what these are supposed to do. But like you said, yes, I've seen other cases where you can actually see the water coming down the inside of the windows. And water leaks are notoriously difficult to fix because it can be a pinhole. Like it can be the smallest little area that's letting water in, and it's really hard to find and be able to properly repair. So you're right. I mean, there's different ways that we can escalate these cases up from minor issues up to Lemon Law, but it's really a case-by-case basis. Depends on how severe your repairs are, how severe is the actual defect, and things like that are happening. Another huge gray area that we see a lot that I'm sure you've seen too, Courtney, is the airbag light. So my airbag light is coming on. What does that mean? Does that mean if I get into an accident, my airbag is not going to deploy? Or what is this saying? And that actually is, I feel like, a issue in which we've had to argue with manufacturers over and bring experts in on of what it truly means when the airbag light is on or off. Because I'm sure you've been told, as I have, oh, no, they'll still work. It's just, the light itself is malfunctioning, not the actual airbag system.
Yeah, that can be a really tricky one. And it also leads to kind of awkward conversations. I was actually in an arbitration one time, and the manufacturer had their expert there and was asking the man how much his wife weighs because she weighed actually too much. And it was making it so that the airbag light wasn't properly illuminating at the right time. And it can kind of be a whole can of worms. But I think that is terrifying. Yeah, if your airbag light is on and you think that airbag's not going to deploy, I mean, to talk about a safety defect, that's maybe the biggest one that you could have. But again, it's really hard because it is oftentimes hard to prove that the airbag actually would not deploy. And it's not just a glitch in the light, because short of actually getting into an accident and having it not deploy, how do you really prove that? And so, yeah, like you said, a lot of times that becomes kind of a battle of the experts, because a lot of times their expert is saying, oh, no, it's still going to work. The light's just on. But we say, well, how do we know that? Because generally, if that light comes on, it means that who's ever sitting there doesn't weigh enough for the airbag to come out, right? I know a lot of times if my dog or one of my kids sits on the seat real quick, that light will come out. Or if I even have a heavy bag on the seat and the car thinks, oh, someone's sitting there, but they don't weigh enough for the airbag to deploy. And that's a terrifying thing. So like you said, yeah, that's something that we would bring an expert in, and you really end up kind of hashing out.
Yeah, it gets really tough. And some laws, like in Ohio, the Ohio Lemon Law, will let you get a buyback just for 8 visits for defects within the first year, 18,000 miles. So it's nice in that Lemon Law allows you to be able to push forward the claim regardless of whether it's a major or minor defect. I mean, it still needs to be obviously something that's substantiated, has required repairs and things of that nature. But you just need to be able to show that you had to go to the dealership 8 times within that initial period to be able to qualify for the buyback. But not all states have that. So you can keep going back and forth for your Bluetooth, your navigation system, your radio multiple times. And while it does strengthen your case, the more visits that you have, the real determining factor to escalate it up to Lemon Law, again, is the type of repairs you're having, how severe is the actual issue, how is it impeding your ability to drive, as opposed to just simply multiple visits.
Yeah, absolutely. The number of times that you go certainly matters, but not if you don't have the right type of defect.
Yeah, because I have a lot of clients call too and say, hey, listen, my vehicle's been out of service for 15 days because my brakes failed on me. I do not want this car back, right? I just bought it last month. The brakes have already gone on it. How am I supposed to trust this car? And unfortunately, even if you do have that safety defect, we still, again, need to show multiple visits or multiple days out of service. You have to hit those markers within the certain time period in order to push it for the buyback. There are some states that have exceptions to that rule. For New Jersey, for example, they only give you one attempt at fixing a substantial safety defect before it can be presumed that it's been an unreasonable amount of time to repair it. But that still means 2 visits at least, right, for that issue. So that means your brakes have to fail on you twice or something of that nature in order to qualify. And it's got to happen in the Lemon Law timeframe for New Jersey, which is 2 years, 24,000 miles. So while you may have the substantial safety defect, there are other factors that come into play too that can make it pretty frustrating sometimes, in the sense of just because you got one doesn't mean you get everything else. You have to have all 3.
Yeah, absolutely. And you brought up an interesting point there. That is correct about the New Jersey Lemon Law, that if it's an ultra hazardous condition, you only get one attempt to fix. But you have to show that it was one attempt to fix and it continued to happen. Because if they fix it in that one attempt, then yeah, there's not going to be a recovery there. So like you said, it does have to be 2 times. And I've had clients say to me lots of times, I had this scary brake issue or the scary something or other, and I just don't want to go pick the vehicle up. They can hold it for all they want. They can repossess it. I don't care what they do. I'm not going to pick it up. And as frustrating as it is for them to hear me say, no, you have to go pick it up, you do, because we have to show that it has happened again. And that's a scary and frustrating thing to hear someone say. And well, how do I know it's fixed? Well, you're not really going to know it's fixed until it happens again. And that seems kind of like a counterintuitive thing to say, but it is completely true. You do have to show that it happened a second time. So you do have to pick it up and kind of trust the manufacturer that they fixed it. And then if they didn't, we can absolutely step in and most likely get the buyback. But you do kind of have to take that leap of faith and pick it up and drive it.
Yeah, I know. I have lots of clients. Well, what do they want to happen? Do they want me to get into an accident? Do I need to be killed in order for something to happen? And it's tough because it's a very fine line, right? If they force the buyback on every car that had a substantial safety defect, it would kind of open the floodgates, right? It would be any issue you had, they had to buy it back. So they had to draw the line somewhere. Professionally and personally, do I think that every state should have that same exception that New Jersey has? Absolutely. I do. I think that New York, for example, you have to visit the dealer 4 times and have the problem continue to exist to qualify for Lemon Law. That's a lot of times. That's a lot of visits for a substantial safety defect, and there's no exceptions to that. The only other way to get around that is if you have 30 days out of service, which you really have no control over. So I agree and can see the frustrating aspect of this all, but a lot of it is persistence. And like we always say, being your own advocate, continuing to take it back, continuing to document these problems, because ultimately you've got to watch out for you and you have to do what's best for you. Because the manufacturer's response to a lot of these defects or problems that you could have, I mean, it all depends. You could call customer care and you could get a buyback offer within a week. You can call customer care and you get nothing but lip service for months. It really all depends on which manufacturer you're dealing with, how severe is your issue, is the dealership supporting you and behind you, It's really tough because these manufacturers, at least in my opinion, don't always do what should be done in the case right away.
Absolutely, absolutely. And we hear that a lot. I tried to institute my own claim with customer care 6 months ago, and they keep giving me the runaround. And that's ultimately why a lot of times people get us involved. And the opposite is true as well. Sometimes you really get a great resolution, and in those cases, you don't need us, right? But a lot of times these manufacturers are not doing the right thing. You get a rep that's really not doing their job, and unfortunately really couldn't care less, and they're just not going to do right by you. And that's what we're here for, to try to push them into doing the right thing. And when they're not going to, you get the law involved.
A lot of manufacturers either evaluate it in terms of a buyback and you get a yes or no answer. And then some of them, that's where the buck stops. They look at it in terms of lemon law. Do they think you could qualify? If the answer is no, case is closed, that's it. They don't always make the alternative, which we always talk about with breach of warranty, for a cash offer for our clients. Or if they do make the cash offer, it's usually just trying to get you to placate you, basically. It's just trying to get you to go away, essentially. They'll offer you, okay, your vehicle is out of service for 30 days. We'll give you that 1 month payment back. Or we'll give you some free oil changes. When really under the law, they owe you a bit more than that for the issues, even if they are minor. You're owed a percentage of your purchase price back, not just, a month of payments.
Yeah, I hear that all the time. They gave me back the couple months payments for while the vehicle was out of service. Well, that's all well and good, but you're actually entitled to a whole lot more than that. Which kind of brings up another question. People often ask us, well, I already accepted that, or I have the check here. Is it all right for me to cash the check and still proceed through our firm? And the answer is absolutely. Unless you have signed a settlement release releasing your future rights to bring a claim against them, we absolutely can. We see it all the time where people have already accepted the money for a couple months out of service, and they should give you that, right? Especially if they didn't give you a loaner during the amount of time that your vehicle was at the dealership. But what people don't always realize is you're also entitled to breach of warranty value, and that's what we're able to get back. And even sometimes when the manufacturer will make that offer to a consumer, consumers don't always realize that that number's negotiable, and that's generally not the final word. And that's another thing that we're able to do for people, is negotiate that number up and make sure we're not leaving any money on the table and get you every penny of what you can get.
Right. And that's what can make it tough, because these manufacturers, so the release, it all depends on what it says, right? We've seen some releases of manufacturers that it only releases claims up to the date of the signing of the release, right? So if something new happens after, you can bring a case. Or we do see absolute full releases where you cannot bring a claim. We're giving you $750 and you're signing away your lemon law rights, which is, depending on what the issue is in terms of where you are in the lemon law period, not always advisable, right? I had a potential client that I had spoken with who didn't quite have a case yet. We couldn't take it on, and the manufacturer was offering her, I think, somewhere a couple $100 to release her claims. And I was familiar with this manufacturer's release that they give to their clients. And I knew that it would only release the claims up to the date of the signing of the release. But the claim that she had was for a stalling condition. So I basically was like, if this problem comes back again, you can't do anything about it. Is this couple $100 that you're getting worth the risk of it returning? So you can either accept it and be like, well, if it comes back, I still have my warranty, fine, I'll take the money. Or you have to evaluate it from the sense of, if this comes back, is this couple $100 worth me giving up these rights? So that's why it helps to have an attorney, because we can go over the amount of money you're getting, what rights you actually have, what are you actually giving up, and how will that affect you down the road if you do, accept a settlement with them. But if you didn't sign a release with them and you just accepted the money, you can absolutely bring a claim. And if the vehicle is repurchased, they just deduct the money that they already gave you from your repurchase money back. But that's usually the worst that could happen. Other than that, it's still fair game, to bring a claim. I wouldn't let that stop you from reaching out to an attorney if you accepted some money, but the issue is still ongoing. Because technically under the law, so we've already discussed at length, repurchases and lemon law, but these cash payments that you're receiving and that we're discussing, the reason why we think that the couple $100 and things are so low is because according to the law, they need to compensate you for the loss in value in the vehicle. So, Courtney, I'll let you expand on what that means in terms of getting a portion of your purchase price back, not just a monthly payment.
Yeah, absolutely. A lot of times people think that money is for their inconvenience, their aggravation, their frustration, and it's not. What the law allows you to recover under the Breach of Warranty Act is the diminution in value of the vehicle, which is determined at the time and place of purchase, which sounds a little odd, but I'll explain it. So you purchased your vehicle and you should have received one worth X dollars. Yours, because of these future issues that it was going to have, was only worth Y dollars. And you can recover for that difference between X and Y. Another way to look at it is kind of like, all right, well, when I purchased it, if I had known that it was going to have these issues, how much less might I have paid? If you buy something from a clothing store and there's a little pull on the hem, it's usually going to be discounted, right? And it's kind of the same thing. It's like they're discounting the vehicle and you can get that money back. Unfortunately, you and I and our clients don't get to say how much that money is. We need to have an expert in vehicle valuation to determine what that number is when push comes to shove, when we're actually litigating in court. When we're talking about pre-litigation cases, we don't usually have to go that far, but we're able to get a good chunk of money back. Now, can we get the full depreciation in value of the vehicle from the time you purchased it? No, because a lot of that is the natural depreciation. The minute you drive a vehicle off a lot, it can depreciate 20% just because it's now a used vehicle and not a new vehicle. So if you spent $50,000 on a vehicle, you had some issues with it, and you go to trade it in and they're offering you $30,000, a lot of times the client will say to us, well, I want that $20,000. Now, can we get that back? No, because a lot of that is the natural depreciation. Now, you weren't planning on realizing that depreciation by selling the vehicle so soon, but unfortunately, that doesn't matter. So that's not something the law will allow you to get back. But what the law will allow you to get back is that accelerated depreciation. So the percentage of that $20,000 loss that was due not to the natural depreciation, but was due to the fact that your vehicle had this ongoing manufacturing defect that they weren't able to fix in a reasonable amount of time. So what it usually equates to is a percentage of the purchase price. 10% is a very across the board number. We're generally able to get somewhere in the 5 to even 20% of the purchase price of the vehicle back.
Yeah, we like to average, like you said, between 10 to 15%, with that kind of going up or down depending on the issue you've had, the types of repairs, and do you have a valid lemon law claim? So some clients that would rather keep the car, especially during the national vehicle shortage. They wanted to keep the car instead of giving it back. We were able to use the potential for a lemon law claim, but hey, we could push this to lemon law and have you repurchase it, but we're deciding to take the faster out and accept cash, and so we'll settle for X. And so we can bolster that number a little bit by doing that, because in a way we're sort of mitigating our claims that we could bring against them through these settlements. And it's tough because these percentages aren't linear, right? Somebody with a $100,000 Mercedes-Benz with a Bluetooth issue does not necessarily get more than somebody with a $35,000 Kia that's also having Bluetooth issues. It's not a perfect one-to-one. Just because you paid more for the vehicle doesn't necessarily mean that you get more. And so that can be kind of tricky too. And again, where you need an attorney to help you, because we've handled these cases so much, taken them to litigation so much, we kind of know where they're going to fall when our expert's number comes in. Because that's always the tricky part, right? When I'm discussing a settlement offer with clients and they say, oh no, I'm not accepting that, I want to go to court. That's fine, but let's talk about what you can get in court. Let's talk about realistically the damages that can be assessed to you. There's no pain and suffering. There's no punitive damages. There are some exceptions for treble damages in certain scenarios where you can show an egregious behavior, but that is so rare. I rarely have ever seen that in my 10 plus years of doing this. So you look at it from the perspective of, okay, either you have a lemon law claim or you don't, or you only have breach of warranty. Our expert usually comes in around this percentage. And not that his percentages are always the same. It's just he has to use a certain methodology, right? So he uses Kelley Blue Book values and the percent difference between the different categories to kind of go back in time and assess the loss in value at when you purchased it. And he uses his experience as an appraiser and understanding of vehicle valuation that all gets added in there too. But because of that the sliding scale does sort of stay usually within some certain percentages that we can give a good ballpark estimate of where you're going to land. And as I say to them, nothing's going to sting worse than if we have X, but we're demanding Y, we go to court and our expert comes in with X, and you're less than what they're offering now. So you really have to do a risk versus reward sort of assessment and pros and cons, because once you file the lawsuit and move on, that money goes away. Whatever pre-litigation offer is there, everything starts over again. And we'll tell you whether we think that's a good idea or not. Ultimately, it's the client's decision. But we don't want to waste your time and take you to court if we think that your goal is unattainable.
Yeah, absolutely. And it's something that's not uncommon to see, is someone to say, no, I just want to go to court. I want to have my day. I want to look them in the face and tell them that they wronged me. And a lot of times you really are just shooting yourself in the foot by doing that. And that, like you said, is something that we're here to advise you on. I'm going to tell you, hey, look, this is a really good offer. And if we go to court, we're not going to see more than that. Now, is it still your right to proceed forward? Sure. But would it be a good financial decision, a good business decision? No. And that's a lot of times what it really comes down to. You have to kind of take the emotion out of it and look at it as a business decision, because you're not going to feel personally vindicated by going and explaining your case either. I always explain it's not an open courtroom. The media's not there. Mr. Ford himself isn't sitting over there. It's some young lawyer that they've handed the file to who probably has 7 more cases after that. You're not going to feel like you really, vindicated yourself and got everything off your chest. More often than not, it's a frustrating experience. You're limited in what you can say. You can only answer certain questions. There's certain things that you can't say. And then you are limited in your damages. Now, the opposite can certainly be true as well, where we think, you know what, this is a really low offer, and we think that we would see more if we go to court. And that's the first thing that we're going to tell you. We're going to say, look, if you're on board with it, if you're planning on keeping this vehicle for the next year, and you don't mind a couple of days out of your time, and you're willing to go to court with us, we think we should do it, because we do think we're going to be able to get that much more money. But that's one of the things that we're here for. Between the two of us, we have quite a bit of experience. So we're able to really pretty accurately gauge these cases and whether it would be a good decision to litigate fully or not.
Right, exactly. And it's, a lot of factors come into play when we're evaluating that. And I have some clients say, well, I spent, $4,000 on an extended warranty. Doesn't that help me at all? Does that help bolster my case? And the tough part is that the only way for the case to qualify is for issues that happen under your factory warranty. So while you paid for that extended warranty, we can't get you reimbursed for that. We can't get them to extend the factory warranty. That's very rare, to have the manufacturer say, okay, we're going to give you X amount of dollars and we're going to give you a lifetime warranty. A lot of clients ask for that, saying, okay, well, they know that this system is an issue, so I want them to warrant it for the rest of the life of the vehicle. And unfortunately, generally, they're not going to do that. And the reason, my understanding of it, is that because the manufacturer can't just push a button and extend your factory warranty. They would have to buy you an extended warranty and apply it to your vehicle. So they assume, listen, we'll just give you the cash. You go pick out whatever warranty that you want, if you do or don't want it, and you can, buy your own extended warranty for the vehicle, because there's so many different warranties now and so many different options. Or you can trade it in, use the money to help trade the vehicle in. And whether these problems that you've had affect the resale value of your vehicle is up in the air. Nobody, it all depends on what's showing up on your Carfax, if anything, because Carfax people seem to think that they have a lot more weight than they actually do, in terms of the only stuff they get is what's reported to them. And there's no requirement that dealerships send them your documentation. So these Carfax reports are not 100% accurate. So whether it'll affect the resale value is unknown. You don't know, unfortunately, until you're trading it in, but that's what this money is supposed to help compensate for. While technically it's assessed at the date and time of purchase, like Courtney said previously, we try to use that to sort of see, okay, if you take X amount of money, the car's worth this, you owe that, this is where you'll land. This will ultimately be where you will land financially if you were to attempt to trade it in, just so you kind of get a footing and know, okay, maybe I need to keep it for just like a little bit longer and put up with the issue to get myself out of any negative equity and things like that. But unfortunately, all we usually end up with in these breach of warranty cases is cash. I've had some extended warranties, or some manufacturers usually agree, but usually like RV manufacturers are the ones that usually agree to extend the warranty. I really rarely, I mean, on the top of my head, I can probably only think of 2 or 3 cases where the manufacturer actually agreed to put a warranty extension on the car, but it's more often than not, they'd rather just give you money.
Yeah, I think you're completely right. It's generally kind of those outliers, those kind of not as common type manufacturers that will do it. You know, the Fords, the Chryslers, the GMs, they won't. But like I always say to clients is exactly what you said, that you can take this money and purchase one. And sometimes that would behoove you. You know, if you're getting $8,000, it's going to cost you $2,000 to get an extended warranty, and you'll still end up with $6,000 in your pocket. Other times it's going to be more worth your while just to trade out of it, especially if you can get a good deal. So a lot of times what our clients will do is they're not sure what they're going to use the money for. They go and they talk to the dealership and see what it'll cost them to trade out, and then kind of make a decision from there. Because a lot of times these dealerships will work with you, especially if you're willing to stay with the manufacturer. The dealership a lot of times kind of feels bad. They're like, look, you know, I know you're having this kind of cruddy experience. Not your fault. It's not our fault. There's just this issue that we really haven't been able to fix. You know, hey, stay with us and we're going to really cut you a break getting you into a new vehicle. And you take that and add to it the settlement funds that you're able to get. And sometimes people end up in a very good financial position, oftentimes even better than they would have ended up had they gotten the buyback.
Yes, because I do have clients sometimes, you know, when they realize you can't get paid in suffering or additional damages on top of it, and we are sort of tied to this percentage, they're not happy with that sometimes. And what I sort of explain to them is, we're going to push them for the most money we possibly can. And it's better than where you are now. Right now, you have a vehicle that's malfunctioning. Yes, you still have all your warranties, but at least you have something back from the manufacturer to compensate you for this issue. It's better than not having, anything from them and just being stuck with a broken car. They should give you something for that. And we do the best that we can to make it work. It can't always be a perfect scenario. Like I say, unfortunately, to some clients, I can't fix the issues that you have right now. I can't make this problem 100% go away, but we can try to make it better. And this is what we can do to improve your current situation, usually, like we said, in the pre-litigation process, so it's not too much of a headache for our clients in terms of what we need from them and what they need to do in order for us to get there.
Yeah, absolutely. And I usually end up saying the same thing. Look, am I going to be able to completely do away with your losses? Likely not. But can I help to mitigate them and cut them? Absolutely. Now, whether that's, because you're trading the vehicle in and you're not going to experience much of a loss, or you're getting this money that's really made up for what you have personally lost because of it, generally it's worth it to file these claims because of that. It takes very little for our client to contact us and send us their documents. That's really about all we need from them, is a quick phone call and send us your documents. And we're usually able to get something that's going to absolutely put you in a better position than if you hadn't filed the claim.
Yeah. And I know that we're always cautious in how we talk about these claims, but most clients are happy. Most clients are happy with the settlements. Most of them do feel that they were properly compensated. But again, we just always try to be careful never to overpromise. And it's important to note too that even if you do accept any settlement from the manufacturer, your warranties are still good. So they don't give you this money and then take your warranty away. You still have what's remaining of your factory warranty. And if you had purchased an extended warranty at the time of sale or at any point, during your ownership of the vehicle, it's all still valid. So you still have your right to repair. You still can bring it into the dealer. They still have to try to fix the problems. That doesn't go away, right? Your warranty is all still there, and your title is not branded either. So a lot of clients are concerned, okay, they're going to give me X amount of dollars, but what am I going to do with a Lemon vehicle? Which would leave you in an impossible situation, right? You'd have a car with a branded title. Good luck getting rid of that thing. But fortunately, when you do these settlements, the title is not branded, right? So the vehicle is not branded a Lemon. It's a confidential settlement between you and the manufacturer. So the settlement itself would not impede your ability to then sell or trade the vehicle in. And as Courtney had explained earlier too, the dealership's not involved in this process. So you can be working a deal for trade with them while we're also working with the manufacturer to recover for you for these cash settlements.
Yeah, that's absolutely true. I mean, you hit on the two things that I always explain to every client once we're able to get money. And those two things are your warranty is still there. It's not like, hey, here's this amount of money. We don't want to hear from you again. Because a lot of times our clients will think that, like, okay, I got this money, but now, I can't go back to the dealership anymore. And that couldn't be farther from the truth. Your warranty is 100% still there. So they're still under a continuing obligation to try to fix this issue. This money is just making up for the fact that they weren't able to fix it in the past in a reasonable amount of time or a reasonable number of attempts. And then two, nothing about this legal claim goes on the title or the Carfax or anything like that. Might some of your repairs be on the Carfax? Sure, but not this legal claim or this settlement. So when you go to trade out of the vehicle, this settlement is not going to adversely affect you. It's confidential. Nobody's going to know about it. So you're still going to be able to get just as good of a trade-in as you would have been able to without the settlement money.
Correct. And all of these points and all of this information is, again, why it's so important to have an attorney walking you through this process. Because trying to do it on your own can be confusing. Customer care does not always give you all the information that you need to be able to make a full informed decision on whether you want to accept the settlement or not. And that's why we always say, listen, give us a call. It's a free consultation. Let us discuss it with you. Even if you have an offer on the table, as we've discussed before, we will tell you whether we think that you need us, or it'd be better, yes, just go forward with this. It's much faster, or what you need to do. So we always recommend going to lemonlawcar.com to contact us should you be having any issues with your vehicle, so we can help walk you through what may seem like a simple process, but it's actually at its core a truly complicated one. And on that note, we want to thank you for being here with us today, and we'll see you next time.
Thanks, everyone. Bye-bye.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary, as outcomes are determined on a case-by-case basis.